Welcome, everyone, to this panel discussion from a woman's perspective, treaty interpretation over time. First, I have a little announcement so that we're all on the same page, is that the organizer have told me that this session is being recorded. So anything that we say or that you will say maybe with your question will go on record, so that you know. Secondly, I would like to introduce my distinguished panelists, starting from my left, Her Excellency Rena Lee, Ambassador for International Law of Singapore. Next to me, His Excellency François Alabrune, Ambassador, then it goes in French, of course, Ambassador of France to the Kingdom of the Netherlands. And online, Miss Akila Radhkrishnan, I did my best, human rights and gender justice lawyer. She's the board chair of the Women's Initiative for Gender Justice, a very known NGO which is based here in The Hague. So, the topic, from a woman's rights perspective, treaty interpretation over time. This evening, we will explore how the interpretation of international treaties has evolved through a woman's rights lens, and the extent to which feminist approaches to international law have shaped the development, application, and understanding of legal norms. Our discussion will consider whether and how international law has adapted to realities faced by women around the world, and examine the interpretative tools that have enabled or could further enable the advancement of gender equality. Before turning to the how, by looking at different areas of international law that may have been affected by this evolution, it is worth briefly considering the issue from a more theoretical perspective. As the interpretation of international treaties truly evolved through a woman's rights lens, and to what extent have feminist approaches influenced the interpretation of international law. And to reflect a little bit on that, I would like to bring us back to 1991, the year in which a seminal article by Hilary Charlesworth, Christine Schenkin, and Shelley Wright was published in the American Journal of International Law. At the time, decades of feminist scholarship had examined and challenged gender bias in national system, while international law largely remained outside of the scope of their critique. Because many assumed that the field was inherently gender neutral. In their article, the three scholars demonstrated that women and girls had been in fact largely invisible within both the normative and the institutional structure of international law. They call on feminist scholars of the feminist community to also direct its attention to international law and to critically engage with its assumption and its structure. From that moment onwards, we begin to see the development of diverse feminist approaches seeking to influence both the evolution and the interpretation of various fields of international law. With this background in mind, let us now hear from our distinguished panel. They will reflect on how fields such as international human rights law, international criminal law, and international humanitarian law and other traditionally gender-neutral areas of international law have progressively integrated women's experience into their interpretative framework, and also they will reflect on the challenges that still remains. To begin, I will ask each panelist a few tailored questions, and after that, I will open the question, well, to you, the audience, to ask questions to our distinguished panelists. Okay? Yes. So, I turn now to Ambassador Alabrune. Over the past decades, the development of international women's rights has contributed to the recognition of gender-specific arms and structural inequality within international law. In that context, to what extent have international women's rights influenced the interpretation of the general human rights treaties?
Good evening, everyone, and Excellencies, ladies and gentlemen. Dear Christine, thank you very much for this question, but if you allow me, I would like to say, first of all, how happy I am to be here today with all of you, and thank you for being so numerous, to discuss 2 days after the International Women's Day, this topic of interpreting treaties, taking into account women's rights perspective. Regarding this question, and thanks also to the Acer Institute for welcoming us, to address the question of how women's rights can be taken into account to interpret general human rights instruments, I think it's interesting to take a case. And I will take a case that comes from the case law of a court I have practiced, which is the European Court of Human Rights. And it's a case which is not very recent. It dates back from 2009, but it is very relevant in my view. And it's a case Opus versus Turkey. The facts of this case were related to domestic violence. It concerned a man, a husband, who had, for a long period of time, assaulted his wife and his mother-in-law. And finally, he murdered his mother-in-law. And of course, the case between Turkey and the person who sees the court, of course, affirmed that the Turkish authorities could not have been unaware of that the mother-in-law's life and the wife's physical integrity were at risk, given, of course, the length of time during which these persons had been threatened. But before that case, the court had never connected the issue of domestic violence with the issue of discrimination and the article of the European Convention on Human Rights regarding prohibition of discrimination. The court had been criticized for not having established that link because the CEDAW, Convention Against Discrimination, had created a basis for establishing this link, and the committee of the CEDAW had also rendered opinions and positions which showed that this link had to be established. And of course, what is very important in the case Opus versus Turkey is that the court had has departed from its previous case law and established this connection, and it showed that to interpret the European Convention on Human Rights, the court took into account this specialized instrument, which is the CEDAW, and the practice of the CEDAW committee. So it's a clear illustration of the way general human rights instruments can be interpreted by taking into account specialized instrument. So it's, in my view, a very clear way of the systemic interpretation of a general instrument, which by a court, in particular human rights court, regional human rights court, which has taken into account this specialized instrument. Of course, there are other cases, other courts which illustrate this possibility and this importance of this systemic interpretation. We could, of course, take a quote, for instance, the African court and the way some cases have been also illustrative of this approach. But this case is a proof that the convention, and the court had repeated this statement, cannot be interpreted in a vacuum. And the convention should be interpreted in harmony with other rules of international law. And as such, it showed that such a systemic interpretation lead to strengthening the protection of the convention. Thank you.
Thank you very much. I move now to the field of international criminal law and stay with gender-based harm. So, Ms. Radhkrishnan, can you hear me? Yes? Yeah, okay. What have been the key factors that have enabled a deeper understanding of gender-based harm and experience in international criminal law and international humanitarian law over the last 30 years? And what challenges persist?
Great. Thank you so much. Thank you to the Embassy of France and to the Singapore Diplomatic Office in The Hague for organizing this really important event. It's really an honor to be participating, and I'm sorry that I can't be there in person. And really on this important question, I think building on the ambassador's remarks, I'll focus very briefly on 3 enabling factors and I think 2 key challenges. So first and foremost, reading women's rights and gendered experiences into frameworks is built on the work of feminist and gender experts engaged in ICL and IHL. This includes the work of feminist groups and activists on the ground who document and expose gender-based harms and violations. I'm thinking, for example, of the landmark Shattered Lives report, which thoroughly documented the experiences of sexual violence in Rwanda during the genocide and was instrumental in actually helping to think about how those experiences were then translated into justice outcomes. And often, and until recently, I think this was the purview of women's civil society on the ground who work in under-resourced contexts to really expose what these harms are. And it's a really important role that they continue to play within this ecosystem of understanding gendered harms in international criminal and humanitarian law. I also think that we've seen, thankfully, over time, this expertise grow and the understanding that there is an imperative to document such harms that are embedded within the mandates of UN bodies. And that's really building on this work. So we see commissions of inquiries, investigative mechanisms, the creation of specialized rosters of gender experts to support this work. We see mechanisms now ensure that gender-based harms are not only recognized within their general reporting with the gender competent analysis pull throughout, but also the impetus to issue thematic reports on these topics. We saw that, for example, last year, where the Commission of Inquiry on the OPT issued a report focused on Israel's systematic use of sexual, reproductive, and other forms of gender-based violence. And so this type of reporting really helps to expose types of harms that were often overlooked in these contexts or thought of as ancillary or secondary to, the issues that we often see in situations of atrocity or conflict. Another really important group of women and feminist activists in this ecosystem are, of course, those who served within justice mechanisms: investigators, legal advisors, prosecutors, and judges. Women like Patricia Sellers, who served as the legal advisor for the gender-related crimes at the ICTY and ICTR, and later to ICC prosecutor Fatou Bensouda, who helped in the 90s to structure both investigation and prosecutorial strategies to take forward charges of gender-based harms. It also includes women like Judge Navi Pillay, who at the ICTR was instrumental in ensuring that charges of sexual violence as genocide were included in the Akiyesu case, which did not initially include such charges. And more recently, we saw, for example, Judge Hilary Charlesworth, who was mentioned in the opening, wrote a separate opinion in the ICJ's advisory opinion on Israel's legal obligations with respect to the OPT, where she highlighted and considered the specific impacts of certain policies on women and on children, really demonstrating the role that judges can also play in this conversation. So I think that is first and foremost the reason that we are where we are, is really the work of feminist experts, activists, and jurists. The second important area is, and I think the ambassador alluded to this in his introduction as well, is often we're working in this space where we're asked to retrofit gendered experiences into laws that never took gender into consideration. I don't know whether I'd call them gender neutral, but certainly I think, some of the laws that we're working with, particularly in the context of international humanitarian law, didn't really explicitly take gendered experiences or give name to gendered experiences, right? You had vague terms like outrages on personal dignity. What we've seen over time, and particularly, I think, building on documentation and precedents coming out of international, regional, and domestic courts, we've seen a broader recognition of what these harms are. And the Rome Statute, I think, was a very important moment where, again, feminist experts gathered to ensure that the Rome Statute actually included a broad range of gender-based crimes, right? So not moving beyond this concept of rape as the only gender-based crime that we saw in international criminal law or violations in armed conflict, towards crimes like forced pregnancy, forced marriage, to enforced sterilization and prostitution. So we saw a much broader range of codification, and giving name to these things then gives the space to take forward charges, right? It is possible, of course, to interpret neutral terms, but it's certainly helpful to have this enumeration. The last thing I'll just say is, as far as enabling frameworks has gone, is we've seen now the creation at the courts, at different mechanisms, of very concerted strategies to actually integrate a gender competent approach from the beginning stages, right? So thinking about what it means in terms of staffing, what it means in terms of their investigation protocols, how you take it forward from beginning to end. And the Syria mechanism, the IIM for Syria, has a really excellent and thorough strategy that they've actually published, that I think is a model for many others to be able to follow in this vein. And I think what this does is often avoid the questions that we would get in early on prosecutions, right? Well, we never saw these crimes. We have no documentation of gender-based harms or of sexual violence. And so the answer is that you do need to start at the beginning, and systemizing these issues is one really important aspect of it. I'll also say in the realm of IHL, where we've really seen progress is when you now look at the commentaries to the Geneva Conventions. When you look at the old commentaries to the same language of the Geneva Conventions, they didn't include much about how to look for gender-based harms, or how gender-based harms would actually factor into the various protections of IHL. If you look at the most recent commentary on Geneva Convention 4, there is an extraordinarily sensitive, gender-sensitive analysis that's actually built into the commentaries to highlight how the various protections of IHL need to actually intersect with understandings of gender, including how gender-based discrimination and structures of gender operate within societies and how those actually inform those protections. So I think that is also really important. Very quickly on two challenges. One is really resourcing. We continue to see that gender is often viewed as a luxury, a nice add-on, and in a world where we are seeing in the multilateral system budget cuts across the board, we see that gender posts, for example, are being cut within mechanisms. They are not being prioritized. And so I think that we continue to have resourcing challenges to make sure that it's great if you have a plan in place, but if you're not able to adequately follow through, you're not going to be able to bring the documentation towards actual conclusions for justice. The second piece is really around, I highlighted the role of feminist experts. We continue to see that there is a dearth of gender expertise within decision-making and leadership. And so just to highlight, for example, at the ICJ, we currently only have 7 women out of 107 judges that have been elected to the ICJ. And more we see issues. The recent case from Gambia under the Genocide Convention that was just argued at the court. We have the upcoming, the South Africa case. There's a pending case under CEDAW that may end up at the court. And really the need to ensure that those who are able to understand these harms are actually at the table to make sure that the issues put in front of them can be understood in a gender competent way. So I'll stop there for now.
Thank you so much. And yeah, talking about the ICJ, we could also make the example of the International Law Commission, which also is a bit lacking behind of not having a fair representation of male and female members on the board. Maybe in the line of your second factor, like the gender neutrality, I will ask a question to Ambassador Lee. When we discuss the advancement of women's rights, we often focus on fields that especially address gender, such as international human rights, criminal law. But how do women's rights feature in other areas of international law that are traditionally gender agnostic? Can the same interpretative technique be deployed to protect and perhaps even advance women's rights in these gender agnostic fields? Please.
Well, thank you very much, Christine, and good evening, everyone. Thank you for joining us this evening. I'm sure most of you have better things to do, so we really appreciate your presence here. Happy to be partnering with the Embassy of France, and also thanks to the ASA Institute for hosting us here. And thank you, Christine, for that question. In some respects, the beauty of coming in last is that the previous speakers have already answered the question. And we talk about, gender agnostic or gender neutral as the term that's used. And I think that is something that Akila, if I may refer to you as Akila, mentioned around the retrofitting a gender perspective into laws that really never considered the issue of gender. And in some respects, you can understand why this is the case, because if you were dealing with a convention on, dare I say, chemical weapons, or a convention on protection of biodiversity, or a convention on design law, it's a little, I think gender is not the first thing that comes to mind. But the international legal system and international law as a whole covers a lot. It permeates our lives in many respects. And if we look at it from a kind of high level, broad perspective, is that they have the different aspects governed in our lives that are governed by international law. When we fly, the rules surrounding aviation, or we like to go on a holiday and we take a cruise, and the rules surrounding navigation, safety, the food we eat, the standards, and those are some of the issues that are actually covered by international law, and they have an impact on how we enjoy our rights as individuals, and how we are able to realize those rights as individuals. And so by extension, therefore, the fulfillment of our obligations in these areas of international law, which have no mention of gender, can actually have an impact on the enjoyment of one's individual rights. And that impact can sometimes be dependent on gender. In other words, the experience or the impact of the implementation of legal obligations may not affect different groups proportionately. And one area in which I think it has been acknowledged that there is a disproportionate impact on women is in the field of climate change. And maybe here I'll share some statistics. Climate change, we know, or the negative or adverse impacts of climate change do have an impact, not always positive, on our right to water, our right to education, our right to work, amongst others. And it is acknowledged, I think, in certain circles, that women have been found to shoulder a disproportionate burden. In many countries, women have the responsibility for fetching water for their households. But increasingly, they find that they have to go further and further and take more and more time to fetch water. And when they fetch the water and they come back, they then have to decide, do I use the water for cooking? Do I use the water for drinking? Because there's only so much water you can carry. And then you have to decide how you use the water. The World Health Organization and UNICEF reported that 1.8 billion people live in households without water on their premises. Women and girls are primarily responsible for water collection in 7 out of 10 households versus 3 out of 10 for men. And climate change also impacts agriculture, the price of agriculture, the food that we eat, and also therefore the household income and the proportion of household income that we spend on food, thereby impacting our right to food and our right to health. And the IPCC Working Group 2 states that women and girls are at greater risk of food insecurity, and it also endangers lives of women who are pregnant because of the heat, because of the lack of food. And then if they are breastfeeding, it also has an impact on the nourishment of their children. And climate change, therefore, implicates the right to health, right to life because of your pregnancy risks, and it can create risks such as hypertension and gestational diabetes as well. Beyond that, disasters, more hurricanes, more tropical storms, extreme weather events cause, and of course for a small island like Singapore, sea level rise, they cause a degree of displacement and food insecurity, and that can, and is an example we saw also during the pandemic and during the lockdown, which can lead to an increase of gender-based violence as well. So I think, therefore, in this context, when we look at the UNFCCC, the Framework Convention on Climate Change, there isn't a mention of gender that I think, as what François said, using the specific, which is the CEDAW Convention and the practice of the CEDAW Committee to interpret a more general human rights treaty, in this case, the European Convention on Human Rights. I think that that can extend to other treaties that are not concerned with human rights, but do have an impact on the realization and the enjoyment of our human rights. Climate change is an example of that. What are the interpretive tools? I think most of us in this room will be familiar with subsequent agreements, subsequent practice. For those of you who have followed the advisory opinion on climate change, you will know that the ICJ utilized decisions of the CMA, the Conference of the Parties meeting as parties to the Paris Agreement. Sorry, we're so used to using acronyms that I forget what the full title is. They use certain CMA decisions taken during COP26 to reflect that our temperature goal today is 1.5 degrees. And that is an example of a treaty interpretation over time using subsequent agreement as reflected by a CMA decision. And there are a number of CMA decisions and COP decisions within the climate change framework that concern gender. And so there is the potential to use those CMA decisions to reflect the subsequent agreement amongst parties in how we interpret the UNFCCC and the Paris Agreement by absorbing in a women's perspective as well. And of course, the subsequent practice as well, because within the UNFCCC, there is a specific agenda item for women and climate change. And therefore, the practice surrounding how states execute, for example, their mitigation strategies or their adaptation plans, those could also constitute subsequent practice, which could help to evolve interpretations of the obligations in relevant laws tackling climate change. Of course, human rights is also relevant in the tackling of climate change. So I guess the short answer is really yes, you could extend the women's perspective to areas of law which don't really reference gender. Thank you.
Thank you very much. And that made me think, linking your two answers to the general recommendation of CEDA number 37, which especially link the gender-related dimension of disaster risk reduction on changing climate. So they link this gender-relating issue and climate change. So I move back to Ambassador Alabrune, and we continue on human rights aspect. Beyond the development of specific legal instruments, feminist approaches have also proposed new ways of reading and interpreting international law. With that in mind, have, or if so, how feminist approaches influence the interpretation of general human rights law?
Thank you. Of course, there is some okay. Of course, there are some similarities or some connections between the two questions. The question of the influence of specific instruments on the interpretation of general human rights instruments, and the question of the way feminist approaches influence interpretation of general instruments. But to answer this, this question, I will take the same method I used to answer the first. I will take a case. And this time, not a case of the European Court of Human Rights, but of the Inter-American Court of Human Rights, and a much more recent case, because it's the opinion, advisory opinion, which was given last year by the Inter-American Court of Human Rights on the content and scope of care as a human right and its relationship with other rights. It was a request coming from Argentina, which had been formulated in 2013 by Argentina. And the court issued a very important opinion in which it recognized the right to care as an autonomous and enforceable human right with three dimensions: the right to be cared for, the right to care for others, and the right to self-care. This opinion is also a good illustration of something I mentioned earlier, of systemic treaty interpretation, because the court took into consideration many sources, universal and regional statutory and soft law instruments, universal and regional bodies, as well as domestic laws. But what is, of course, more relevant to answer the question you pose is the way the court has taken into account what can be called feministic approach to international law. And I would take two aspects in this regard. The way the traditional distinction between public and private has been challenged by this opinion, and the way the court has taken into account the necessity to have a wide diversity of perspectives. First aspect, the way the traditional distinction between the public sphere and the private sphere has been challenged. This aspect is something which is really relevant for what can be called feministic approach, because this traditional approach has, of course, been criticized because it leads to it has led traditionally to ignore some aspects which were considered as private and so not relevant for public international law, and considered as less important, maybe relevant for private international law, but not for public international law. But of course, this traditional distinction, as I said, has been criticized. And in regard with care, in 2018, the ILO had published a report on this issue of care, underlying that unpaid care work, of which 3/4 is performed by women, makes a substantial contribution to countries' economies, as well as, of course, to individual and societal well-being. And the report underlined that this unpaid care work remained mostly invisible, unrecognized, and unaccounted for in decision-making. And this is why the opinion that the Inter-American Court gave last year is so important, because the court, of course, recognized an autonomous right to care in international law. And by doing so, the court, of course, underlined, I quote, that care work isn't a natural extension of women's role confined in the private sphere, but labor with immense social and economic value for the public sphere. And as such, must be regulated by states. It was a question, of course, the precise question also raised by Argentina. What are the obligations of states regarding care? So the public-private distinction has been challenged. And second approach, which is characteristic of what can be called feminist approach, which is taken into account. I quote Hilary Charles-Worth in a text dating back from 1995. She wrote, "Feminist analysis of international law involves recognition of the need to develop situated perspectives that encourage awareness of the differences between women while also recognizing their commonalities. And she added, listening, attending, seeking to understand the perspective and realities of different groups identifying or identify as women is a fundamental aspect of feminist methodology. And it is very interesting to find in the opinion given by the court a reflection of this approach. Because the court, in its opinion, recognized that care burdens are not evenly distributed among women. And I quote the opinion, indigenous, Afro-descendant, migrant, and low-income women face disproportionate responsibilities and multiple layers of discrimination. And this recognition aligns with feminist movements and phases on the way gender, race, class, and migration status intersect to shape inequality. So I think it is very, very interesting to see how this approach, feminist approach, which we found in a 1995 text of Hilary Schaffers, is inspiring, has inspired the court's opinion. Thank you.
Thank you. Thank you very much. And also to mention that in their critique in 1991, so 4 years before they were talking, they were basic also the critique of this invisibility of women on the public-private distinction, which happens, which often makes women fall under the private sphere and be invisible to international law. But I'm going to go look that advisory opinion. Thank you. Moving on, well, going back, moving on to international criminal law. In the world of backlash on gender, where and what are the opportunities to continue the progressively development of both fields, ICL and IHL, to be more gender competent? For you, Akila.
Yes, thank you so much, Christine. And Ambassador Alabrune, you set up kind of where I was going to begin this so perfectly, because I think, you know, I'm sitting here in New York. It is the Commission on the Status of Women, which is notoriously difficult to negotiate around issues, right? And we saw over the last few weeks and yesterday the difficulties kind of around the issue of gender. And I think that we need to be having this conversation in the way that we just did, which is really think about how gender is a lens of many that helps us understand and unpack a situation, right? So the ambassador kind of walked us through in the context of care using, you know, I think all of us here have probably read, you know, Judge Charles Worth and Christine Schenken's work quite a bit. But really what that is, because I think in a lot of the conversations that I end up in, gender is viewed as some sort of hammer to impose certain values, right? And it's seen as, you know, and it depends on the context in which you're talking about. It could be seen as a backdoor to, you know, ensuring access to abortion, which feminist lens have exposed why, for example, access to reproductive health care, access to abortion is essential to the realization of women's human rights and all those who can become pregnant. But it's not like necessarily what gender means or what a gender lens always brings to the table, right? And so I think in this context, we need to be having this nuanced conversation. So in the context of international criminal law, in the context of international humanitarian law, gender is a lens that helps us understand atrocity and conflict. It is something that tells us why not just women may have been targeted for acts like sexual violence, but it also tells us why men may be targeted with particular types of violations, right? In work that I've done around the intersection of gender and genocide, we look at why is it that men are often targeted early on in genocides for killing? And why is it that women are often separated from men? and they're targeted for different types of acts. All of that is a gendered analysis. And so I think we need to bring in this conversation, when we talk about gender, when we talk about what feminist and intersectional perspectives bring, it really helps us understand every individual's experience of conflict and atrocity. And I think that is a framing that helps us move forward in this discussion and away from the polarization of the viewpoint of, gender competency, the concept of gender as something that is Western, something that seeks to impose particular values. So I think that is really important in the work that all of us are doing. And it's clear in Ambassador Lee's intervention as well, that looking at how gender helps us understand these experiences, whether in climate change, whether in the home and within the care economy, whether within situations of atrocities, there's a real through line there. The second thing I think we really need to think about as opportunities is where we're at and where we need to go in our understanding of gender-based harms. So we started in a place where sexual harms, particularly rape, was really the act of gender-based, was basically synonymous, right? That gender-based harm in the context of atrocities was just synonymous with sexual violence. And I think we're in a space now and we're starting to see precedents in regional and domestic courts, as well as at the international courts, for example, around issues of what reproductive violence looks like. What does it mean when the act or what the interest that's being violated is not sexual, right? Where it is, in fact, reproductive autonomy or integrity. In the Ongwen case at the ICC, where I was privileged to serve as an amici, the court really came forward with the really, I think, careful and useful explanation of how it is that gender-based harms stack against each other. So they looked at, the acts of sexual slavery and rape as violations of sexual integrity and autonomy. They looked at forced pregnancy as a violation of reproductive autonomy and integrity. And they looked at forced marriage as a violation of relational autonomy, really understanding that different types of gendered harms have different interests, that the crimes themselves are protecting different interests. And this is how there's no one all-encompassing act, right? Rape may be an underlying act of many of these crimes, but in fact, it does not encompass the totality of the experiences and of the gender-based harms, and how it is that we need to have more nuance in moving forward in that part of the conversation. The last thing I'll offer is a process that I'm very engaged with now. The UN has finally started the process of negotiating the first global treaty on crimes against humanity, which has, state responsibilities to prevent and punish. It includes mutual legal cooperation, includes a broad framework to really strengthen the architecture of international law as it relates to atrocity crimes. And there we've seen a very important opportunity to actually take a progressive gender approach to the treaty. So what does it mean to be gender competent in the treaty? And for that, we've looked at two aspects of it. One, process, because we often forget that if you do not lay the groundwork for a successful negotiation on issues such as gender, we're not going to actually be able to get substantive outcomes. So what does it mean to have gender parity and gender expertise brought into the framework of the negotiations? I'm happy to answer more in questions if there's further depth that's required. And then also looking at what does it mean to actually take a substantive gender approach towards the content of the treaty. There are proposals on the table, for example, to codify specifically enumerated gendered harms that don't exist in the Rome Statute, which was largely the basis of the document. That includes deprivations of sexual and reproductive autonomy and integrity, or reproductive violence. It includes proposals to codify forced marriage, the slave trade, as well as the concept of the emerging norm of gender apartheid, which is something that we're really seeing coming out of the situation in Afghanistan. And we also see opportunities to think about other ways to ensure that a document like that is gender competent, ensuring issues like modes of liability actually take into account the types of ways that, the types of modes that you need to include to ensure that justice can be rendered for gender-based harms, where often you're not looking at one-to-one acts of violence. And so I think that the treaty, we really see the treaty as a generational opportunity to put some of these conversations that we're having in this room into practice, because it's a moment where we have much deeper understanding of what gender-based harms are, even from when we negotiated the Rome Statute. And really, if this is a treaty for the next 50 years, as we have this conversation now about what it means to bring these perspectives to the table, I think we really have an opportunity to concretely put them into law.
Thank you very much. Going back to climate change, in recent decades or two, climate law has shown growing efforts to develop a more explicit agenda in advancing women's rights. Why is this work important? How would a meaningful gender-responsive agenda look like? And have you observed, Ambassador Lee, any tangible progress being made?
Thank you very much for that, Christine. Maybe I just run through where we are in the context of the work of the UNFCCC in terms of gender, and then maybe try to answer some of these questions. So when we look at the start of this UNFCCC process, usually every year around November, December, you start seeing a lot of media articles around climate change, where literally tens of thousands of people will swarm and descend over a particular venue and spend 2 weeks talking, many times across each other instead of listening to one another. But it all began in 1992 with the adoption of the United Nations Framework Convention on Climate Change. And if you look at the UNFCCC, there was no reference to gender, no reference to women at all. And the early work of the COP really did not focus on gender until sometime in the 2010s, in the early 2010s, where we began to take a look at the question of gender. It's kind of sobering to think that it was only in 2010 that we started looking at gender in the context of climate change. In 2015, in the Paris Agreement, you will find some references to gender equality and adopting a gender-responsive approach, and that's specific to adaptation plans. And I think from there has been increasing emphasis on integrating gender considerations in climate actions, beginning with the Lima Work Programme on Gender that was adopted by COP20 in 2014, and then the Gender Action Plan adopted during the Fiji COP, which was held in Bonn because there was a big storm in Fiji in 2017 that had 5 priority areas around capacity building, gender balance, participation, and women's leadership, coherence across UNFCCC bodies, gender responsive implementation and means of implementation, monitoring and reporting. And last year in Belém, at COP29, there was the adoption of the 9-year Belém Gender Action Plan in last year. So it seems as though we have made progress in the context of gender and climate change. And I think what Akila mentioned, and particularly maybe in the context of negotiating the Convention on Crimes Against Humanity, is looking at it from a process point of view and then looking at it substantively. Because when we talk about gender balance or gender equality, you can approach it from a process point of view. And usually when we look at gender balance or gender equality, and I know there are differences between the two, there's a tendency to do a quantification. Like, let's look at numbers, and say how much are the numbers. Because, of course, it is an important first step. In order for you know, there must be participation by women to articulate for themselves their perspectives. So yes, the numbers do matter, and that's why we keep track of it. And in the context of the UNFCCC, the Secretariat does keep track of the number of party delegates, how many are men, how many are women, how many are in the different bodies, how many are heads of delegations and deputy heads of delegation. And invariably, you will find that while there may be somewhat equal numbers of women and men participation, invariably in the leadership positions, you will find that there are more men. And this is an important first step because you need the women to participate because sometimes it takes one to know one. And you need the women to participate. But when we talk about even procedural, the procedural aspects of gender balance or gender equality, it is not fulfilled merely by numbers. And I think it's also important that we don't think, oh, we reached 50%, there's 50%, and therefore there is gender balance, and we're done. We don't need to do anymore because we're done. Because the other aspect beyond that numbers, the numbers are important, but beyond the numbers is how substantively do we realize or do we incorporate that women's perspective. And there I think is a little bit more challenging because in some respects it references what Akila mentioned about understanding that perspective and having the expertise in that area. But I want to end off by referencing another process, and this is the negotiations for the treaty on biodiversity in areas beyond national jurisdiction, which I was privileged to preside over. The adoption of the treaty took place on this day that is celebrated in New York. It's called the International Day of Women in Diplomacy. And women played quite a key role in the conclusion of the BBNJ treaty through the facilitators, some heads of delegation, some members of the bureau. They played an important role. But what I said was for us to realize the promise of the BBNJ agreement, we have to reach out and partner the men. There will be no solutions if we work in our silos and we don't reach out to each other and partner one another. And this is true in every respect. Men, you are part of the solution. Please don't take this as this is nonsense. You are part of the solution. So I think it is important that we work together. That's why we have François. Because we have to work together in order to be able to deliver concrete outcomes in the realization of women's perspectives. We need to join hands, and let's do so. Thank you very much.
On that note, that's I think it's worth an applause. No? So, I now would like you, the audience, to join the discussion, and I open the floor to your question. And one thing I realized that I don't know from the technique, do we have a microphone? Yes, okay. We do. We have two even. Thank you. So, there is a first candidate.
Thank you very much. Good. Is this on? Yeah? Can you hear me? I need to speak louder? Okay, that's a first. All right. Thank you very much. This was excellent. I enjoyed it very much. And I wanted to add another treaty that's under scrutiny in 2026. UN Charter, Article 97. The SG, he shall be the Chief Administrative Officer of the organization. Now, we all know that he does not prevent a woman from taking over the organization. So the big question is, why hasn't a woman become Secretary General? And at the end, it's not a legal impediment. it's political. And I think it's important then that those that support gender equality, and I'm one of those, you walk the talk, and if you tell those to follow that path, then you have to show that you believe in it. The SG, the current SG, he's a feminist. So you can have a man who's a feminist, you can have a woman who's not a feminist. The question is, and it's something that Ambassador Lee mentioned, how do you incorporate these approaches and perspectives? Because we can't all read advisory opinions. Maybe France can host this annually, and that would help the Hague crowd. But I think it is important that those that are in decision-making positions or in leadership positions are able to have access to more awareness of how to have these feminist approaches, because it's important for both. And as I said, you can be a man and be a feminist, and you can be a woman and not be a feminist. And so to have more access to that. Thank you.
Who would like to comment, answer?
Thank you very much, Christian. I would not, of course, comment on the choice of the next Secretary General, but of course, having a woman would be, of course, an excellent way to show the importance of the role of women in the international community. But as you said, and Rena has also underlined this, and your two comments were very consistent. The importance is for women or for men to be aware of what is at stake, and in this regard, dialogue is so important. And Rena said something very important, that we should not be in silos. We should really have more and more opportunities to dialogue and to also educate, because of course the choice of top officials is very important, but the education of the next generation, in my view, is also very important. And I think the education is a key aspect of this debate. Education of girls and of boys, because it starts, I talked about care, and of course this issue is also extremely influenced by the role models that are given to girls and boys from the start. But I'm of course far from the initial question, and maybe my co-panelists would have something to add.
Maybe Akila might want to say something. Maybe Akila might want to say something first.
Happy to add, and maybe as the non-governmental representative in the room, perhaps I can speak a little bit more candidly. No, I mean, I think that this is an incredibly important question. And, you know, as someone who does a lot of my work here at the UN, I walk by, there's 2 hallways at UN headquarters that have portraits of all the Secretary Generals. And so every time you walk by either one of those hallways, you're always struck by what the leadership of the UN has looked like. So I think, you know, it is for the legitimacy of the organization, there is an imperative around this issue. And I think there is also an imperative because, and this is me coming more from my work within the feminist movement and within these spaces, and less perhaps as a legal expert, is, you know, oftentimes to succeed in these places, women have to emulate male leadership characteristics, or, you know, they have to be, their expertise has to be viewed as general. Therefore, if your expertise is in feminist issues, in gender issues, you are not viewed as having the necessary experience to lead a general organization like the United Nations, right? So I think there's still a lot of work for us to do in having this nuanced conversation about both the imperatives around equity and parity and what expertise looks like. I also have a slightly controversial opinion on this that I'll just put out there. which is, again, there is no question for me that there is an imperative. It is also interesting to me that we are in this space where we may be dovetailing around having the first female SG, but where the institution is in real crisis. And we have a tendency to put women at the top for the first time when something is falling apart. And so it's something that I sit with a little bit in terms of, you know, the fact that we have these extraordinary candidates, female candidates, that have now been put forward. And at the same time, what it's going to look like for them to take leadership, because both of the really, I think, difficult multilateral context, which women are perfectly capable of taking on, but rather the fact of where we've come, and also that there's a lot of decisions that are being made about the UN that the new SG is going to inherit and perhaps not be a part of creating the solution. So for me as a feminist, I do have these questions in the back of my mind as to what are the other considerations we need to be having in this moment around this issue.
Yeah, maybe if I can add something from a more personal perspective, but yes, I agree, men can be feminists and women may not necessarily be feminists. We shouldn't assume. I think fundamentally is that let's not assume things of people, but have, as François says, dialogue and conversation around this issue. And as a point of reference, our permanent representative in New York is a UN gender champion, and it's a he. He's a he. Is that right? Yes, he's a he. So it entirely reflects that we should not assume that men cannot be gender champions, because they can. But I wanted to share on a personal note my experience because I think it maybe illustrates that we still have some ways to go. When I was elected as president of the Intergovernmental Conference, I received what I acknowledge to be very well-meaning advice, but which in some respects caught me by surprise, because I received advice on what clothes to wear, how I should present myself. In particular, I was told to lower the tone of my voice because my voice is too high-pitched. And honestly, yes, I admit that if you go on UN TV, because many of the sessions are open, and you look at the session, you will realize I sound like Minnie Mouse. And when I was elected, and you know, it's like if you've ever been in the UN, sometimes you will go up to the chair and you will greet the chair and you say good morning or before the session starts. And I received many comments when I was at the table, which would say, "Oh, Madam President, you have a new hairdo today," or "Madam President, are you wearing a new dress today?" Or "Madam President, have you changed your glasses?" They didn't want to engage with me on the substance of the work. And I can assure you that in all my years in working in the UN circuit, I have never, ever once gone to a male chair to say, "Mr. Chair, is that a new tie you're wearing today?" I've never, ever done that. But because of certain, I don't know, perceptions or tropes or I don't know what, people, you know, they see that it's perfectly fine to be commenting on a woman's appearance and mannerism and how I act. And I kind of accept that they were very well-meaning. And in fact, many people congratulated me, but said, "Oh, it's great because you're a woman." But I like to think that I was elected not because I was a woman, but because I knew the area well enough. And I think it's not to put women in leadership positions because of gender, but because they are experts, and not to discount them from leadership positions because they are women. Thank you.
Is there another question in the audience? Yes?
Thank you. Thank you. Um, can Akila hear me online? Hi. My name is Angelica Wahona. I'm from Women's Initiatives for Gender Justice. Thank you very much once again to the Embassy of France and also the Diplomatic Office of Singapore in The Hague for having this discussion. We're very glad that our board chair board, Akila, is able to be part of this important discussion. My question is with regards to the current backlash that we're currently seeing in many different fronts with regards to gender issues, as have been discussed in the panel. How do you ensure that with regards to treaty interpretation and in treaty negotiations, that the experiences of women in their varying identities, women of color, lesbians, transgender women, but also people with gender identities that are still underrepresented in many forums, such as intersex people or gender or non-binaries, are taken into account and continuously involved to ensure that substantive equality that we hope for. Because I think in women's initiatives, we believe that true feminist approaches is looking at using gender lens as a tool, but looking at it not just through a binary lens, but making sure that the issue of all of the genders are accurately and addressed and carefully addressed. So curious to hear the views of all of the panelists.
Yeah, would you like?
This time I will go first. I don't think there is a single answer to your question because it depends on the subject matter of the negotiation and the rules, and as Akila mentioned, the process, how the negotiations are arranged. And every negotiation process is a little different and organized a little differently. We don't go into negotiations assuming that they are all one and the same processes. So to some extent, and I'm sorry to sound like a typical lawyer, the answer is it depends. But I do think that it requires those of us who have already that ability to be in the room to be able to articulate the need for the participation. It may not be all the time as in the can I say in the same room, but the ability to be able to share your perspectives with others as well. And I'll give two examples. First example is that I was involved in the negotiations on the Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge. And we talk about associated traditional knowledge as the traditional knowledge belonging to indigenous people. And we had taken an agreement that even in informal working groups, the indigenous caucus would be able to be in the room to advocate for themselves in the protection of their associated traditional knowledge, which I personally found very inspiring because they were not relying on those of us who don't belong to the indigenous community to articulate for them. The other example I give again, and I'm sorry to sound like a broken record, is the BBNJ agreement, where in some circumstances we had closed agreements, but in meeting with members of when I met with members of civil society or other observers, I did encourage them to organize programs, and we made space for them to be able to share their different points of view. Of course, in the question of biodiversity, it was a lot of scientific and technical discussion. But that's not to say that a specific gender perspective, and I take your point that it isn't binary, it isn't male or female, it isn't all women, because within the class of women, there are also different groups, that there is that potential. And again, how we approach it depends on how that particular negotiations is set up to be able to address some of these issues.
Akila, would you like to add something?
I'm happy to jump in, but I feel like Angelica's probably heard me speak about these issues. No, I think that's right. And I think building on Ambassador Lee, I think a lot of this is a challenge to all of us who are often in spaces where we have access and we actually are in the role of creating space for more people, right? Who do we put on panels? What voices are heard? Who do we deliberately make sure that we reach out to make sure that they understand what these processes are? How do we understand what their experiences and priorities are? So I think there's also, from a civil society side, I think we continue to need to be challenged to continually do better on these issues and to be more inclusive and to be challenged as well, because sometimes I think there's, even within civil society, a fear of issues coming up or challenges coming up in bringing folks who are not usually at the table. But I think we need to think of it as an invitation and an opportunity rather than something that is, scary. Complexity in this world that we're working in, where gender manifests in many different ways and gendered harm manifests in many different ways, it is in fact complex. And so we need to welcome complexity and challenge. And so I think it's also, to me, a call to make sure that those of us who are engaged in these processes make sure that these perspectives are very directly at the table, as not as Ambassador Lee was saying, we don't have to be the translators, but rather it's our role in the privilege that we hold to be in these spaces to create more space.
Thank you very much. I don't think I have a lot to add to what has been said by my two co-panelists, but of course the question is the question of the negotiation and how such concerns and priorities are taken into account. Of course, Rena has already mentioned some aspects and some examples, but in such a process of negotiation, the first aspect is how the negotiators are themselves aware and how they are able to take into account such concerns. So it also raises a question of the preparation and the dialogue which, before the negotiation takes place, between those who are going to negotiate and those who can inform them and share with them this sensitivity, and also how the authorities, which of course gives directions and directives to the negotiators, are also themselves. So there is, of course, this first aspect. The second aspect is, of course, the interaction between delegations, which might not all share the same views about this issue, because it's obvious that sometimes there is not international consensus on this. So it's important to create also dynamics between delegations which share such concerns in order to influence and to convince and to, of course, create a process which leads to results. Sometimes it's not easy, especially in the universal framework. But these are, of course, aspects which are more practical, but which have to be taken into account.
I think we have time for one or two more questions. Are you all tired and you want to go have dinner? That's Charlotte. Yeah.
Hello. First of all, thank you very much for hosting this event. My name is Charlotte Tremblay. I'm a student of Ms. Tremblay at the Hague University of Applied Sciences in International and European Law. And I have a question for Ambassador Lee. As you've mentioned, the advisory opinion on the effects of climate change that was preceded last year at the ICJ, and you've also mentioned it in the context of gender and gender equality and gender protection. And I wanted to ask if, because when I was reading the verdict last year, I remember that I barely saw any mentioning of that and also of minority or vulnerable groups. And I wanted to ask if you still think that that was a milestone in that direction, or if there's still something positive that can be pulled from that in regards to the connection of environmental protection and women's rights, or if that was lacking more, or if that should have been discussed more in that context, especially since also Judge Charlesworth was part of the proceedings as well. So I wanted to ask you if you still think that it was a success, or if it should have been better discussed in the context of human rights and especially women's rights and vulnerable groups as well. Thank you.
I think that the advisory opinion on climate change was significant. I guess hard to define what a successful advisory opinion is, but was significant in a number of ways, but perhaps not necessarily in the context of gender. Gender was referenced, and I think the court made a passing reference to the CEDAW Committee's general comment. But you will notice that gender was not the only aspect of relevant law that got a very, very brief mention. To some extent, it's the range of what was done, what was covered, and an advisory opinion isn't given out of air. It depends on how the question is framed, and these questions on advisory opinions are framed very carefully. But I do want to highlight one aspect of the advisory opinion in the context of women, which I think is something that is positive. One is that when you look at the participation, and I don't have hard numbers on this, but one is when you look at the participation of those who advocated before the court in the advisory opinion, you will realize that many were doing it for the first time. And many of those advocates, they didn't go the usual route of hiring external counsel from big law firms. But even some of those who did hire external counsel, the counsel were women. Many of those who were advocating their country's point of view on gender were women, and young women at that. And you know, of course, how the advisory opinion on climate change was begun. It was begun by a group of law students in the Pacific, of which many were women. And so to me, although the advisory opinion itself may not have covered in an in-depth manner the issue of gender, I think to some extent it's because of how the question was framed. But I think I take the positive of the involvement of women in the advocacy. And this is true, by the way, when you look at COSIS and the advisory opinion by the International Tribunal on Law of the Sea. The persons behind COSIS, many of them were women as well. And I take this as positive and really, in a way, looking at the next generation of lawyers coming into this space that maybe will have a more nuanced view of how we approach some of these issues. Thank you.
One last burning question. Oh, there are two. One in the back. Let's see.
Hello, my name is Anastasia Sivash. I'm the research intern at Asa University. So I was working during my master thesis, I was working on the issue of transitional justice and conflict-related sexual violence. And what I noticed is that the states often brush away the issues of victims of conflict-related sexual violence for the sake of reconciliation after the conflict. And the main issue was the lack of political will to really look into the justice for the victims. So my question is there something that can be done to enhance and sort of increase the political will of the states, maybe through interpretation of the IHL instruments or other ways so the states won't brush these issues away in the bigger scheme of events? Thank you.
Akila?
Sure, I'm happy to start. I think I think you're getting to some of the questions when we talked about what are the challenges that we're still grappling with, right? I think where we have made progress is at certain levels. We have actually seen that gender-based harms are taken more seriously, and I think if you look at, for example, Colombia, and the cases that have come out of the HAP, there they've actually really integrated gender-based harms into the into understanding what it was that happened in Colombia and how those need to be understood and resolved in order to move forward. So I think there are positive examples that you see as well. I think we are still unfortunately in a place where we have a lot of work to do in moving from where we do have these understandings and certain legal judgments and law to actually having to shifting narratives right within a broader society of how gender-based harms sit, because I think we unfortunately still are in a place where rape, sexual violence, domestic violence are seen as personal. They're seen as something for the domestic sphere. They're not seen as the responsibility or the purview of the state. And in some contexts, culturally sensitive. And so I think we still have a lot of work to do to translate what we often, what we are touting as wins towards these broader reconciliation processes, because I do think, and I think that is mind shift change. And there are amazing feminists who are fighting tooth and nail in every country affected by atrocity for exactly this. And I think we need to think about how we make sure that they're at the table, not just in presenting information, but that they're a part of the design of justice mechanisms in the first place. Because often where we fail is that, I was just looking at something on the South African Truth and Reconciliation Commission, right? And they kind of did this ad hoc process to add on considerations of women's experiences under apartheid. But it was not a part of their mandate. It was not a part of their infrastructure. And they didn't think of it as a core part of what they were trying to look at, understand, or, accomplish in truth telling and in reconciliation. So I think that, one of the key things we really need to be pushing for is the meaningful participation of women, not just in processes, but in the design of processes themselves.
Thank you. Somebody wants to add something?
Just very briefly, I think that international courts have, in particular, courts, of course, specialized in human rights, have, and I gave this example of the European Court of Human Rights. And there is also a much more recent case which is related to France last year about an issue which is very particular, which is what we call in French le devoir conjugal, which is actually this rule under private law regarding marriage, that you have a duty to have sexual relations in your marriage. And this is a very old rule, but of course it can lead to abuse, it can lead to, of course, rape in the context of marriage. And the European Court of Human Rights last year considered that this rule, as it was traditional in the French civil code, was contrary to the European Convention of Human Rights. So I think that one of the ways to, of course, address this reluctance of states to take this into consideration is really the referral to international courts, which have, in my view, an important role to play.
Thank you. It's good. Yes. Should I give you the floor for the question, or do you? I think if you can bear with me, short question. Thank you.
Yes, thank you for the very insightful panel. My question is to Ambassador Lee. You spoke about going beyond the mere numbers in gender balance to have that more substantive representation. I wanted to hear from you whether there are some general indicators which you could give to us of how we can tell when there is that actual substantive representation in negotiations. It might be a bit contextual as well, it might depend, but in general, those targets that we could say, okay, here we have actual substantive representation.
Thank you. And I'll give the, during the BBNJ IGC, I asked the UN Secretariat to keep track of numbers. And towards the end, I don't have the exact figure down to the decimal point, but it was about 48% women who were government representatives in the various delegations for the IGC. But most of the heads of delegation were men. So not really in that decision making space. But I take heart at that as a development, not from a mere numbers point of view, but these are women who are maybe in the first 5 to 10 years of their career, and that as they progress in their career, I think more and more of these women will come into leadership positions and will be able, again, without the assumption that all women are feminists, will be able to perhaps bring a greater degree of consciousness around gender issues in the work that they do. And that is why I am a big fan of, in a way, capacity building, because it's also about encouraging not just the women, but the men as well. François spoke about boys and girls, but I think it's also about the women and the men and how we can work on these issues as well. Yeah.
Thank you. So I think it's time to close. I would like first to thank, and if you want to join me to applaud our distinguished panelists. And I wrote that we did excellent and targeted contributions, so thank you so much. And also I would like to thank you, the audience, who took time of your very busy schedule to come here and talk about this important topic on Women's Day, well, almost on Women's Day. So thank you. So you also deserve an applause. And thank you, Asser Institute, for facilitating this event. Thanks.